Yes. You want to withdraw with leave to file afresh?
My lord, my lord.
Ashun. The learned advocate for the petitioner submits that there are certain defects in this writ petition and some documents have not been annexed and some documents have also not been annexed thereto. Have also not been annexed thereto. Stop. He prays for leave to withdraw this writ petition with liberty to file afresh on the self-same cause of action. Stop. The learned paragraph. The learned advocate for the respondents does not oppose such prayer. Stop. In view thereof, WPA 76 of 2021 is dismissed as withdrawn with liberty to the petitioner to file afresh on the self-same cause of action with better particulars.
Deeply obliged, my lord. Great.
Yes. Next. Call the list.
Here, I am appearing for respondent number 123, my lordship. Led by Mr. It is your man.
Yes. Where is Mr. Jaipal? Pass over. Next.
Two is also identical matter, my lordship. That's why this.
Yes, 1 and 2 pass over.
Yes, ma'am.
Yes.
But I am for the respondent in this matter. Yesterday or day before yesterday, but affidavit in opposition has been filed, my lord, in this matter. The service is, my lord, required to be done. I'll serve them on Monday, my lord. Otherwise, soft copy I have, but I don't have their email address. And hard copy I will be able to provide them on Monday, my lord.
You are for the petitioner. So, will you file any reply to that? Soon. When have you filed opposition? Opposition, ache? Hai? No, this.
No,
Oh,
but day before yesterday I filed.
yes. You are filed in the department.
I filed in the department.
The affidavit in opposition has been filed by the respondent numbers 2, 3, and 4. First up, the learned advocate appearing for the respondent number, learned advocate appearing for the said respondents prays for time. No, prays for time. No? Undertakes to.
My lord, I beg to appeal for the petitioner. Extremely sorry, my lord. My lord, I think they have been filing a report on the form of affidavit.
Yes, they are filed. Do you
This
file any counter to this?
Yes, my lord, I will be filing a rejoinder to this. Not a rejoinder, exception to this.
All right. Exceptions to this. This is not a report only. This is an affidavit. So you can file
Is there affidavit?
Yes, report in the form of an affidavit, you can file exceptions to this. So,
I'll file an exception to this.
all right. How soon can you serve? Yes.
Hard copy I can serve by Monday, no. Soft copy, my lord, I can serve to him in his mail today only.
Yes, you
Soft
can
copy is-
supply
Yes.
your email ID.
A soft copy will do. Yes, a soft copy will do.
Uh, huh? Now the third way. Full stop. Undertakes to serve a copy of such affidavit upon the learned advocate for the petitioner on or before February 5, 2024. Full stop. The learned advocate for the petitioner prays for time to file an exception to the said affidavit. Full stop.
1 week's time will do, my lord.
It's such
My client will.
prays for 1 week's time. Prays for 1 week's time. 1 week's time to file. To file. Yes. Time to file. No, list this matter before the next available circuit bench. Full stop. Petition.
Will be getting expired on 15th of February.
My lord, the interim order is expiring on 15th. That will be extended till the.
The petitioner will be at liberty to file exceptions to the affidavit on or before the next date of hearing upon serving an advance copy of the same to the learned advocate for the respondents. Upon the learned advocate for the respondents. Full stop. The interim order, which was passed on January 10, 2024, and is no, is starting 19th of February. So extended to February 28, 2024, or until further orders, whichever is up.
My lord, what I say, my lord. My lord, I'll be in Andamans on 28th of February. I'll be there. I have another matter fixed, my lord. The
Yes.
date may kindly be fixed on that day,
Of,
28th.
I have said list this matter before the next available circuit bench.
Very well.
Circuit bench, I can-
Obliged, lordship.
Yes, next. Oh, list has gone out.
I'm sorry, I was held up in the other.
Yes, yes.
But there is an urgent matter. Yesterday, order was passed and I have been given a demolition of my house today. If the matter is not taken up, if it is taken on Monday also.
What is the item?
It's, as on this list, this has to be taken, or otherwise by Monday, they would Saturday, tomorrow is a holiday, they would demolish it. As on this.
What is the who is the authority?
What is the revenue department?
Who is-
Yesterday, the meeting was held and I've been given a threat that it would be demolished today or tomorrow. Tomorrow is no good, everybody knows tomorrow. But leave may kindly be granted, so that I can move as on days this summer. Till Monday, some protection and training for.
But you have to serve who is appearing
Not
for.
the dispensation under route.
No. You serve who is appearing for the authorities.
Dispensation, Mr. Arun is there, Lord. I can
Yes.
serve.
I am there also, Dipesh sir. Dipesh sir nahi hai?
Serve.
Just, till Monday.
So where is your pleading with regard to urgency?
Urgency, I have pleaded, Lord can find in paragraph 15, that there is extreme urgency looming as each of the respondents.
Paragraph 15.
15 of the petition, not
Yes.
page 10.
Page 10. Yes.
There is extreme urgency looming as each of the respondents parties are bent upon to cause prejudice to the repetition by constantly attempting to disturb the possession of the repetition from the subject land towards which which in a very fast manner, improved order has been passed without hearing the petitioner, and then threat is being administered on 1/2.
No, you are challenging the order dated 19th of January.
No, 19th of January order along with a notice. Do not kindly see page 57 once. 57 once. Last annexure P7 may kindly be seen.
Yes.
Do not kindly see. There is a suit pending. The
No, no,
file-
that is a different thing.
Hold on,
This is
page-
the,
Page 57, not yesterday was the date fixed before in the chamber of respondent number 1.
yes.
I have been given a threat to vacate the dwelling house. Otherwise,
But no, order has been passed.
no, order of the Tahsildar, I'll show. The order of the Tahsildar.
No, pursuant to this meeting was convened on 1st of February.
Yes,
Any order has been passed.
page 55 may kindly. Order was passed at first, at page 55, without hearing me. 19th, and no hearing, nothing, in a haste manner. And a notice was given. I have informed the Tahsildar at page 56. I have informed the Tahsildar there is a suit pending. Kindly refrain from executing in page 56. Then Lordship, page 57 came to be passed. Yesterday I was called. I have been given a threat of disposition, Lord. Just for 2 days, some protection may kindly be granted. Lord, the suit is pending. The private respondent's wife filed a suit for my eviction. It's pending.
All right, Sarvima copy,
Lord,
come at 1.
I'm grateful. I'm grateful.
It is to be published in the supplementary, published as
I'm grateful.
supplementary. Yes. So Jayapal, Sarvima copy,
I have given it.
you
I've
take
given it.
instructions.
I've given it. I've given it.
Yes, call the next matter.
They were supposed to place certain reports which they have been.
That transport
Transport
matter. No, this is not transport. Mr. Jayapal, this is not transport. You are also appearing, but
Yes, yes.
it's a different matter.
And I'm for respondent. my lord.
Yes, this is
I-
not the
I-
transport
Look,
matter.
sir, Item number 4 है ना?
Writ petitioner is an applicant in a proceeding under order 21 rule 97 which is pending before the court at Mayabandar. Lord, his possession was protected by this court.
So this is that matter. Both the writ petitions were heard. No. All right.
The order 21 rule 97 proceeding as judicial is pending. The Tahsildar under the garb of demarcation wants to evict me. Lord, my concern is I should not be evicted without due process of law, particularly when my possession has been protected by this court by an order. I will show, my lord.
Show me that.
My lord, it's at page 58. At one point of time, Your Worship, that this judicial case was dismissed for default. I approached this court straight away without taking recourse to the restoration application. Then this protection was conferred. Based on this order, restoration was filed, it's pending. And my possession has not been affected till now.
No, this 58 is,
Order of this court, Your Worship.
yes,
Hamza.
direction dated such and such, the direction of the belief to take further steps
It's
and
stayed for a period
proceed
of 10 days.
10 days. What happened after
I
that?
filed the restoration, it was restored, it's pending before the Mayabandar. I've said in my pleading.
But is there any interim order there?
No, see, the possession this court granted.
It's for 10 days.
But the trial court has confirmed the order.
Where is that? Where is that order?
That Mayabandar,
Mr. Jayapal,
they say one thing,
yes,
sir, they want to evict me, Lordship, on the ground of demarcation.
show me that notice.
No notice, nothing. No notice, nothing. That's the point, Lordship. I'm occupying the land, I'm entitled to get a notice.
Yes, what is
My
your
lord, I have
instruction?
taken instruction, my lordship. We are not doing any demarcation, my lordship. I consider.
So I'm recording that.
Yes, my lordship.
Uh,
And moreover, my lordship, the remedy is there before the trial court. They can approach the trial.
no. Trial court is between the private parties. His allegation is that the Tehsildar is disturbing his possession in the
And-
garb of
and-
demarcation.
Can apprise all the.
Mr. Jayapal, where have you stated that they are taking steps for demarcation?
But there is no document.
No, when it is without due process of law, then they cannot be done. Not page 7, paragraph 6. That now during the pendency of the appropriate proceeding, this judicial case 1 of 16, at the behest of private respondent and his men, the respondent number 3 herein visited subject line on 12/1/2020.
Yes.
And admitted.
Ashwin. The writ petitioner has prayed for an order restraining the respondent authorities, particularly the respondent number 3, particularly the respondent number 3, from interfering with and disturbing the possession of the petitioner in respect of what is the property?
The decretal property, not I'll show the decree.
No, have you said anything?
I'll say in the petition. It's a survey number at
Uh,
paragraph three.
in respect of the
Paragraph three.
decretal property in title suit number 10 of 2020, full stop. It has been stated in the said, it has been specifically stated in the said writ petition that without serving any notice of demarcation, the respondent number 3 has fixed a date of demarcation of the subject land, and in the garb of demarcation, the petitioner will be ousted from his possession of the property involved in the said title suit. No, decretal property in the said title suit. Involved na kore? Decretal property in the said title suit. Full stop. The learned advocate appearing for the respondent number 3, comma, upon instructions from his client, comma, submits that the respondent number 3 has not yet taken any decision for demarcation of the said land. Full stop. Recording such submission of the learned advocate for the respondent, the writ petition stands disposed of.
So the affidavit of service as against current respondent file will be taken on.
একদম উপরে করে দেবেন। Affidavit of service filed in the respondent, private respondents have been served. Affidavit of service filed in court today is taken on record. Full stop. It has been submitted by Mr. Jaipal that the private respondents have been duly served. Full stop. In spite of service, full stop. In spite of service, none appears for the private respondents. Next.
Obliged, my lordship.
It's filed in the office to us. Normally, the affidavit is filed in the office. You put it there. in the office.
তাহলে affidavit of service not filed in court today.
It's in the-
No. কেটে দিয়ে filed in the department. Yes. He submits that. Mr. Jaipal, you have filed today in the department. Yes, in the department today. ঠিক আছে? Yes, next. Call the next matter.
This matter, you put writ petition, my lord. The,
Yes.
Respondent authorities has to be served, my lord, because they are at trial. I had seen put writ-
They are?
They are at trial in my lord, the office. Here the preliminary decree, final decree has been passed for partition of the property. Notice has been issued by the respondent authorities, but they are not passing the final. order.
My lordship. Let a copy may be given, my lordship. I will take instruction, my lordship. Let it be fixed on Monday, my lordship. Meantime, I will take instruction.
Their notice is appearing at page number 44.
But you have not served notice upon the respondent. No,
They are issued there, ma'am.
There is.
I have sent it.
no, is there any private party involved?
This
Why?
is here.
Who subdividing the suit property? You have said.
Yes, my lord, among the legal, I'm just asking for the representation, my lord, the respondent authorities.
No, a suit, you have filed a suit for partition.
Yes,
Partition suit has been decreed in preliminary form.
And
Thereafter-
and finally,
Final decree.
in terms of the report of the
Yes.
officer,
So if it is,
subsequently-
so you have to approach the civil court for execution of the final degree.
No,
What-
no, but here the regulation speaks that, my lord, we have to make an application before the deputy commissioner. He will in terms of the order passed by the civil.
But why have you not included the private parties?
And will be given on the.
Yes.
Inter में copy में भी sir.
As prayed for by the learned advocate for the petitioner, leave is granted to the petitioner to file an application for addition of the, they are the defendants in the suit.
Yes. I will-
Where do I find the names?
The names should be appearing in the preliminary decree, my lord, page number 30.
30,
3 2
32.
There are 17 of them, I will.
For addition of all the plaintiffs have also not joined
I think, but I will include every.
to implead
For-
the
for-
for addition of parties who were parties in title suit number 46 of 2012 before the learned civil judge, senior division, Mayabandor. Full stop. Liberty to mention after filing of such application. Next.
Oblige, my lord, sir.
Yes, next.
I can think no for but we both want to do the matter during the circuit, but not today, on Monday or.
Not today. As jointly prayed,
Urgent matter, 1 o'clock.
as jointly prayed by the record করে দিন, as jointly prayed by the learned advocates for the parties, list this matter on February. I'm fixing it on 6th, February 6th, 2024, because on 5th, many matters have been fixed. Yes, next.
What has happened was second appeal. And the respondent. But out of two, one has not been served with the appeal. He was the main respondent. So this is a proceeding under order 9. Decree was gone because both the court below have dismissed the suit. But in the second appeal, eviction decree was granted. But the main respondent, upon whom the appellant was directed to serve notice, has not been served. In his absence, the entire appeal was taken up and it was allowed, and eviction decree was.
You are challenging that eviction degree. What is the ground in your order 9 rule 13? Non-service of notice.
Non-service of notice. There are several orders annexed with the plan application. My lord can find the appellants were specifically directed.
So have you served upon the other side?
Mr. Ajay Mandal was all through appearing.
So I'm making it not.
Mr. Mandal is not good. He has got the viral fever.
All right. Not today. Next.
Which is for the writ petition is payment for it's better I think
What do you want?
LMG connection. I chose a piece of government to be led in another item part. I started deciding with.
Where is your application for electric connection? 10. Yes.
I applied.
Online application.
Can be? Yes. Ashun.
Terms of the larger bench judgment.
uh, the writ petitioner claims to be in occupation of a government revenue land bearing survey number 1/P, measuring an area of about 200 square meters at Birshanagar, Attampahad, under Port Blair Tehsil in South Andaman. Is residing there along with her family by constructing a dwelling house thereupon. Full stop. Yes. The petitioner applied for supply of electricity on 8th of September 2023, but supply of electricity has not yet been effected to the petitioner. Full stop. Paragraph. After hearing the learned advocates for the parties, WPA 101 of 2024 is disposed of by directing the
Exponent number 2, madam.
by directing the assistant engineer, electricity department subdivision 2, South Andaman, being the second respondent, to consider the application for supply of electricity submitted by the petitioner on 8th of September 2023 and to effect supply of electricity to the petitioner upon compliance of necessary formalities as expeditiously as possible, but positively within a period of 4 weeks from the date of receipt of a server copy of this order.
On small indulgence, my lord, this electricity will not create any right and equity or.
It is however made clear that supply of electricity shall not create any equity in favor of the petitioner.
My lord, as so far as the respondent number 2, it is Patrapur, my lord, Assistant Engineer, Electricity Department, Patrapur. But my lord has said division, subdivision.
But it has been said here.
My lord, in my copy, it is Assistant Engineer.
I think in this copy, after putting in whiting, some corrections have been made. And that is this subdivision 2.
Let it be make it as respondent number 2, my lord. The Assistant Engineer, it can be done.
But the
I don't know, my lord, because it is written Electricity Department, Patrapur, South Andaman.
yes, who is the appropriate authority?
But I think in my
Respondent
copy, it
number-
has not been corrected, but in online application, it is right, my lord.
What is the online application? It says what?
It says Assistant Engineer, Subdivision 2, Electricity Department.
Subdivision 2.
Yes, yes.
Yes, so I have said
I'm
that.
sorry, my lord.
This
But in
copy
the-
has been corrected.
I'm sorry, my lord.
All right. Yes. Next, call the next matter. And disposed of. Yes.
9 WPA 1/4 of 2024.
But same order be passed.
I am for the petitioner, my lord.
Same order can be passed.
Same order, only
It should be
Survey number and
survey number 88 by P. Same order as in the earlier matter. Survey number 88/P. Area 500 square meters at Guptapara village under Ferrarganj Tehsil South Andaman District. And when the application was submitted,
26, my lord.
26,
Six.
applied for supply of electricity on 26th of June 2023.
Lord, it should be,
June 2023. And
it also
election
respondent
will
number
be upon the Assistant Engineer Electricity,
Choldari subdivision.
Assistant Engineer Electricity Department, Choldari Subdivision, South Andaman.
Yes.
Subdivision South Andaman, respondent number 2. Disposed of. Next.
Obliged.
Obliged.
The respondent is on his legs before.
Not today. Next.
Both Mr. Chakrabarti and Mr.
Next.
So Mr. Jayapal is for the petitioner by you. I'm
Not
for
today.
one respondent at one for central government is I think.
Not today.
For respondent.
Not today. Yes, any matter. Both sides are ready. Yes, Mr. Nag. Yes, yes. Can start. Only I will be taking 5 or 10 minutes at 1 p.m. for that matter. Yes. Where is your other side? Where is your other side? You can start. Mr. Tabriz may join you. What is the item number?
Item number
15. Yes.
This is default in payment of it. That is the case.
Eviction on the ground of.
On the ground of default in payment of.
Yes.
Your Lordship, the story went like that. He issued a notice.
Show me the substantial question first. Thereafter I will.
Yes. I find a cross appeal also. So, page number 263, Your Lordship, of the paper. 263 of the paper.
No, you are for the appellant. Why
Appellant
cross
is-
appeal?
In the first court, Your Lordship, so far as arrears of rent was concerned, that was some limitation was given by the learned court, the trial court. That is the reason why I find a cross appeal when they find the appeal against eviction.
Because you have got the decree for eviction.
Arrears of rent, because some limit was.
So cross appeal against
Cross
that.
appeal.
So what happened what did the appellate court do?
So far as the cross appeal is concerned, it was plainly dismissed.
And so far the other side's appeal is concerned,
That is allowed.
that was allowed.
Yeah.
So a eviction decree was passed against you.
No. Eviction decree was passed in my favor. I am the landlord.
So why are you the appellant?
Because first appellate court set aside the eviction decree.
That is what I am saying. So the first appellate court has set aside the decree.
I am the landlord.
Yes.
I prefer the appeal. Your Lordship, page number 263.
263 is the substantial. No, 267 is the substantial question.
267 in the cross appeal.
Oh.
263, Your Lordship, in this appeal. 263.
This is SAT 5. 5 is the cross appeal.
5 is the main appeal.
So
I can
in
see.
5 paper book, I find 267 is the substantial question of. Oh, there are two bucks. Yes, yes.
Both the things I have in it. Because together.
Yes.
Whether the court of appeal below was justified in reversing the judgment and decree of the trial court solely on the ground that the notice remarking the arrear of rent does not specify the provision of law under which the same has been issued. The second question, whether the court of appeal below was justified in reversing the judgment and decree of the trial court without noticing that despite an order having been passed for the deposit of arrears of rent, the tenant did not request the same and therefore exposed himself liable to be under regulation
25,
30 months of Panama or Islands Rent Control Regulation 1964. Apparently, sir. So these. So I just wanted to place these facts of the case to become very clear, Your Lordship, what actually has happened.
And the other appeal is page 267, the
Yes.
substantial questions of law.
Whether it is imperative on part of the court of appeal below to record an independent finding while disposing of an appeal pertaining to the recovery of arrear of rent. Because no independent finding was there. That's it. Whether the court of appeal below was justified in discussing the bill without determining its independent finding on the merits of the case and therefore expose the individual judgment liable to be sent. Not even a single sentence is there about my appeal.
Yes,
Just
Yes.
a feedback note. A notice was issued initially, starting fact arose your lordship when he issued a notice to me. He issued a notice stating that I am no more interested to continue with the tenancy and determining the tenancy
tenant issued a notice to the landlord.
land. And determining the tenancy provided you refund my security deposit in full. I replied to that notice stating that so far as determination of tenancy is concerned, I'm accepting it. Tenancy is determined, but I will give you the amount after deducting the rent, what you have not paid. And in the paragraph also, separate paragraph is also written with regard to the rent, that you have not paid the rent from this particular date.
So in your reply to
In
his
my-
letter,
Yes. The point that, on the basis of that reply, thereafter find the suit. The point is that whether that reply will constitute a notice under section 106 of the TPM term. Because as per our regulation also, notice has to be issued. This is actually important. My submission is that what is a notice?
according to you, the reply shall be construed to be a notice.
Because demand is there. Main thing is demand. I am demanding. When I have demanded, you have to pay. Not only that, during the pendency of the matter before the trial court, I filed an application under section 14. Because under the regulation, section 14, one provision is there for the court to decide the amount of rent to be deposited by the tenant. That's
Once the suit is filed,
once the suit is filed. So that application was allowed in my favor and he was directed to make the payment.
the amount was determined. This amount is, he is liable to pay.
Liable to. He did not follow that. Till today, he has not followed it.
So according to you, non-compliance of that automatically results in a decree for eviction in your
Yes,
favor.
this default has been proved. Section 14(7) though saying that the court can pass an order for holding that he is a defaulter, but that doesn't mean that if no separate order is passed, there cannot be any eviction considering the order passed for payment of it. One thing is that demand is there. Second thing is that order is there.
Adjudication.
Adjudication.
Adjudication directing him to deposit.
Deposit. And the learned trial court considered all the facts because he has admitted even in the cross-examination that he has not paid the rent. So where is the question of further proving anything, Your Lordship? And even now he is not paying the rent. He's occupying the premises, not paying rent anything. Many years have passed, simply occupying the premises and keeping them. This is the case. And now I can show one by one everything. This is
And why your cross appeal?
the arrears of rent was not calculated properly. That is the reason.
So you are challenging the section 14 order.
Not 14 only. The ultimate also, the trial court has looked into the calculation and modified the calculation to certain extent. That I was not satisfied. So
Show me that operating part of the trial court judgment
Yes.
once.
Page number 199.
199.
Yes.
Yes, 199 is the decree only. No, sorry, it's 193 because there is an overwriting, that is why.
Starts from 199.
Yes, I've got 199. Take me to that portion with regard to that calculation part.
Yes.
What is the issue? That issue number,
Issue number the 6.
6 page,
290.
219, yes.
Issue being the conclusive issue, I find that in the case of the plaintiff, the defendant being the parent and the chief, by virtue of the lease deed has failed and neglected to pay the rent as per the lease agreement. So the plaintiff has paid for releasing the defendant from his property and also has paid for a direction upon the defendant to pay the earlier rent as is due from the month of September 2012 at the rate of 23,000 per month. The defendant contested this application and pending inter alia, it is only in possession possession of 8% of the tenanted premises, and it is the inaction on part of the plaintiff for which he is prevented from possessing the entire first and second floor as per lease. It was also alleged that at the time of entering into the lease agreement, the plaintiff fully conceived the fact of existence of order of injunction passed by civil court with suits filed by other co-tenants against the plaintiff. While adjudicating the issues, it has already been held in issue number 3. The defendant is a tenant and the plaintiff as a relationship has not been disputed by the defendant. There is an existence of a lease agreement dated this, which has been admitted by either of the parties. It was also followed by a series of receipts filed by the marked as exhibit F that the defendant has paid the money towards the payment of the rest of the.
It's now only 1 minute. Kindly come to the operating part at 2:22.
Yes,
So there was a default.
yes, sir.
There was a default. So on that ground, an eviction decree was passed. There was an adjudication of a quantification of the areas and a direction was passed to pay those areas amount.
Yes.
So does it not amount to double jeopardy? Because the consequence of default is eviction. So I have defaulted and evicted. Either way, so again, that defaulted amount is directed to be paid. If it is directed to be paid, then why eviction? Does it not amount to double jeopardy? You are directing him to pay, you are also evicting him for the same offense. Offense is one default. For that,
It is not for the purpose of eviction, it is for the purpose of possessing the premises. You have, I have incurred.
show me that these directions can be passed for recovery as well as eviction. Show me that.
I can place the judgment in. I'll place the judgment on Monday.
Show me from the provision first, thereafter judgment.
Silent. Provision is silent. Provision is silent with regard to that.
This is what is troubling me. That is why I asked you, since you said that you are cross appeal,
Just a minute.
because on the for the default in payment of rent and eviction decree has been passed, and that defaulted amount has also been directed to be paid. Whether this is possible under the statute,
Yes, yes, but arrears of rent is.
because so far as West Bengal Premises Tenancy Act is concerned, no, there are judgments.
Yes.
Could I make my point clear to you? Could I make my point clear to you, Mrs. Na? What was your prayer in the plaint?
It was there. Arrears of rent.
Areas of rent was also there.
Yes, arrears
Whether
of
this
rent.
is permissible, so you can recover the areas and also the default will follow. Can it be done?
Just a minute.
Penalized twice for the same offense. It is against the basic principle.
Your Worship, my submission is that a particular person was enjoying the premises. For that, he is required to pay the amount.
Default is for that. Default is since he has not paid for the period he was in occupation. That is the ground of default. And consequences provided in the statute is eviction. So he will be evicted and he will also be directed to pay that. Show me that statute permits that. Either you can recover rent, that is one part, or you can pursue your remedies for eviction. You cannot pursue both at the same time.
It is just a-
If you want, I can give you time on this.
Yes, yes, Your Worship.
Because this
Because
is,
there I have certain.
because this is
judgments
what
over-
is troubling me.
And even our regulation speaks about it.
Yes, show me the regulations
That's what.
with regard to that you can recover as well as evict for the self-same offense.
I'll come on Monday. I'll come on. I'll answer this question.
Ashun, after some argument, Mrs. Nag, learned advocate for the appellant, pressed for an accommodation to assist this court on certain legal issues which has cropped up. Legal issues which have cropped up in course of hearing. First up, as prayed for Mrs. Nag, list this matter on
Monday.
February 5, 2024. Yes, where is Mr. Mr. Tabraj is opposing you in this?
Yes,
Where is he?
I inform him.
Yes.
Someone.
If you have any decisions on this, you can place that because
I will just.
so this is the, we have several decisions, similar provisions is in the West Bengal Premises Tenancy Act. I tell you why. Similar provisions, more or less similar. Default ground eviction. Now, the tenant can get protection if he earlier 56 Act was section 17, 17(1), after appearance, he has to comply with the monthly deposits. Any dispute 17(2). So an adjudication is to be made. Now in the new act is 7(2), almost pari materia provisions. Thereafter, if non-compliance of 17(1), 17(2), defense can be struck off and proceedings. And ultimately, if the finding is of default, eviction. But those questions have arisen, know that whether for this, there is an adjudication that he is a defaulter for so many months, whether the tenant can recover that amount. Decisions are no, cannot.
It is valid.
Because Mrs. Nag, that strikes at the basic root. Because what is the offense? Is the default for the period, default in payment of rent for the period in occupation. So he is being evicted. So he is penalized in one way. He is also been directed to pay, penalized again for the self-same offense. This goes against the basic principles of law.
The loss which the landlord has incurred in the occupation of the.
For that,
landlord
he is
goes-
getting, Mrs. Nag, for that he is getting eviction. Let us suppose he comes on the first day, pays that amount, no eviction decree. So you are getting. So if he pays, you will not get eviction. If you get eviction, you cannot get. Two things you cannot get at the same time. Satisfy me, Mrs. Nag, on this.
Monday I will come.
Because this goes against the basic principle. You are getting, it's not that you are not getting anything. You are getting eviction. Whether you can get both at the same time for the self-same default.
I'll look into it, I'll come.
Thank you. Yes. Call the one. Supplementary list has been published. Yes.
I got some copy to Mr.
Yes. What is your instruction?
My lordship, only meeting has been taken place. There is no decision has been taken till now. my
No
lordship.
decision.
No.
So I'm recording that. I'm keeping it on.
Yes, my
Mr.
lordship.
Jaipal, I'm recording that.
There are private respondents also there, my lord.
Kindly have a look to page 55 once.
Yes.
Tahsildar has already taken a decision to evict me. It was under.
All right, but it will not be executed. That is his instruction. I will record that.
Yes.
Yes, you have taken instruction that
Yes,
it will
ma'am.
not be
Yes, ma'am.
executed.
From
I'm
the-
putting it on private respondent is there.
Yes, there are two other.
I will serve it as the, because 47, not 48 hours, that's not for dispensation.
I'm representing one
Serve. How soon can you serve and come back?
On Monday, bro. On Monday.
Yes.
On Monday.
For 1 to 6, I'm representing.
Monday.
This matter was mentioned by Mr. Jaipal, learned advocate for the petitioner, citing urgency. First up, considering the urgency pleaded by Mr. Jaipal, this matter was directed to be listed in the supplementary list today. First up, pursuant to a copy of the writ petition has also been served upon Mr.
Arun S. Kumar, my lord.
Mr. Arun S. Kumar, learned advocate, who is representing the respondent numbers 1 to 6. First up. By drawing the attention of the court to the order dated, order of the Tehsildar, Port Blair Tehsil, dated 19th of January 2024. Mr. Jaipal submits that an order has been passed directing eviction of the petitioner on or before 25th of January 2024. Full stop. He further refers to the notice of meeting dated 31st of January 2024 at page 57 of the writ petition, wherefrom it appears that the petitioner was directed to attend at the meeting convened in the chamber of the Chief Secretary, Andaman and Nicobar, Chamber of the Chief Secretary, Andaman and Nicobar Administration Secretariat on 1st of February 2024 at 10 a.m. Full stop. Mr. Jaipal submits that pursuant to the said notice, the petitioner duly attended the said meeting, and in the said meeting, he was threatened that his client was threatened. In the said meeting, the petitioner was threatened that he will be evicted today. Very shortly. I'm making it very shortly, Mr. Jaipal. He will be evicted very shortly. Very shortly. Today, very shortly. Full stop. Paragraph. Mr. Kumar Laner, advocate, appearing for the respondent number 1 to 6, upon instructions from his client, submits that the authorities have not yet taken any final decision to evict the property, to evict the petitioner from the property in question. Full stop. Such submission is placed on record. Full stop. Petitioner is directed to serve a copy of this application upon the respondents by registered/speed post with acknowledgement due, and file an affidavit of service on the next date. List this matter on February 6. I'm giving 1 day because Saturday, February 6, 2024. Yes, your submission has been recorded. Instruct your clients accordingly.
Yes.
Yes. Any matter? Both sides?
Obliged, my lord, sir.
Any matter where both sides are ready? All right.